The Chief Justice, Ronald George, whom you'll meet momentarily, decided that the court should be more accessible and more known to the public. And so the court embarked on a series of, on a road tour, as it were, and held arguments not only in its usual spots of San Francisco, Los Angeles, and Sacramento, but also in other places like Fresno and San Jose and Santa Barbara, which we'll talk about in a bit. And they were broadcast on the California channel. It really was envisioned as an educational program. High school students were involved, and the proceedings were televised on the California channel. And they thought they needed some kind of an introduction to the court, some kind of an explanation about what the court's role is in the judicial system. And so I happily was commissioned to make a video about the court. And we had a great star to star in our video. Ronald George was Chief Justice at the time, as I said, and really welcomed us inside and allowed us to go places that folks don't generally get to go, like through all of the chambers and even to watch the court in conference, where only the 7 justices generally are in attendance. And then that video was both broadcast on the California channel before these extra sessions, but also it became something that we could send to students and other groups like that interested in the court, but who wouldn't get much of a tour if they actually came down. So that's the genesis of this video that you'll see today. We'll show it now, and then we'll have a chance to talk a bit about it.
In San Francisco, across from City Hall and the Civic Center, the California Supreme Court presides. This classical building has been the court's home since 1923. Inside, the 7 justices of the Supreme Court have the final say on California law. Every year, more than 8 million lawsuits are filed in California. Some 9,000 of those seek review in the Supreme Court, but not many are successful. The court issues only about 100 opinions annually, focusing on major issues of statewide importance. Ronald George is Chief Justice of California. He is, in effect, chairman of the board of the California courts, with 2,000 judges, the largest judicial system in the world. The chief, as he's known at the court, has been a judge for more than 30 years. The governor appointed him Chief Justice in 1996, giving him responsibility for the Supreme Court and for all other courts in the state.
I figured out that my time tripled when I went from being an associate justice to being Chief Justice, and I still give my all to the opinions, but I've learned to get by on a lot less sleep in terms of all the administrative responsibilities. Sometimes I'm asked, why do you have your robe hanging in the corner of your chambers instead of the closet? And I say, with all my administrative responsibilities, I like that reminder that I'm actually a judge who sits on the bench.
George is the 27th Chief Justice of California. Portraits along the hallways and a brass plaque in his chambers memorialize those who came before. A sense of history is heavy in the air.
It certainly is. You're looking back at that history, and personally, myself as a Deputy Attorney General, I was arguing before some of the greats, including Chief Justice Roger Traynor. So having been an advocate before the court, perhaps I had even more awe and admiration for it, and certainly could not ever imagine myself being here.
The California Supreme Court was created in 1850 in the heady days of the gold rush. Originally, there were 3 justices. Serranus Clinton Hastings was the first Chief Justice. A native New Yorker, he headed west and stopped first in Iowa, where he became Chief Justice of the Iowa Supreme Court. After gold was discovered in California, he pushed westward across the mountains. 4 months after his arrival, the state's first legislature appointed him Chief Justice. Today, his name lives on at Hastings Law School, located just a block from the court. Fires, floods, earthquakes, and politics forced the court to move 22 times, mostly in its early years. After a number of locations in San Francisco, the court moved briefly to San Jose when that was the state capital, and then to Sacramento. In the 1870s, the court moved back to San Francisco, and there it has remained. As the court's caseload continued to grow, 2 new members were added in 1862. In 1879, the court was expanded to 7 justices, where it remains today. So far, there have been more than 100 justices, some legal giants, some less so. They are remembered by the historic photos in the hallways, inscriptions in each of the chambers, and most of all by their opinions in 400 volumes of the California official reports.
These bound volumes that you see behind me here embody our decisions. So we're very careful about what we write because they're there forever, basically.
No justices have challenged each other to a duel anytime recently?
No, not like our predecessor, Justice Terry, who in fact did that and mortally wounded somebody in a duel and then himself was killed in an act of violence when he approached somebody aggressively. We had, in the gold rush days, a lot of very colorful characters who perhaps consumed more alcohol than they should have and were more prone to act out in violence and in other ways. They were very colorful days in the early history of the state.
The court lost its longest-serving member when Justice Stanley Mosk died in 2001 at age 88.
It's incredible to think that he served on the court for approximately 37 years, which is almost 1/4 the entire history of the state of California and of the California Supreme Court.
Whatever their stature, or gender, or legal philosophy, all of the justices are cloaked in the same black robes when they take the bench.
It's traditional, and the basis for the tradition of the robe is that it symbolizes the impartiality. We are attired identically, and it, I think, is supposed to reflect the fact that justice is to be blind and neutral. And it's actually required by statute that we wear our robes.
The justices gather in the robing room before sessions of court.
We don't have any formalized procedure like the U.S. Supreme Court, where I understand they each shake each other's hand, but we are there for a couple of minutes and exchange greetings, and then basically we file out to do our job. You can never tell whether there'll be a barrage of questions from all 7 of us almost simultaneously, or whether there'll be these deathly periods of silence that sometimes unnerve an attorney even more.
Good afternoon, ladies and gentlemen. Are ready to start?
Supreme Court arguments are much different than a trial. There are no witnesses. There is no jury. There is no evidence. It is a serious dialogue between lawyers and judges. The 7 justices sit on the bench in order of seniority. Lawyers for each side usually get 30 minutes to present their arguments and answer the justices' questions. Except in the summer, the court hears arguments the first week of every month. In San Francisco, the court sits in its historic courtroom, recently restored to its full architectural glory. 4 months each year, the court hears arguments here, 4 months in Los Angeles. And for 2 sessions each year, the court returns to its historic courtroom in Sacramento, in the shadow of the state capitol. On occasion, the court sits elsewhere.
If we disagree on that part,
Before oral argument, the justices have read the briefs and staff analysis and made preliminary decisions about the case. The arguments are a final opportunity for lawyers to persuade the court.
The opinions very frequently are affected by oral argument in terms of things being changed. Now, in terms of a 180-degree flipping the case around, that occurs rarely, but I have seen it happen where before we even have our robes out, we're looking at each other saying, well, that certainly changed things, didn't it? And the loser comes out the winner.
After arguments, the justices immediately confer about the cases they've just heard. The conference is held upstairs in the Chief Justice's chambers and is strictly confidential. Only the 7 justices are present.
We each have a designated seat, and there is a brass plaque at the back of each seat, in order of seniority. So for many years, Justice Mosk sat here. Now Justice Kennard is the most senior justice, and we go around the table in order of seniority with the junior justice speaking last, and then finally the Chief Justice after that.
So this is sort of the holy of holies here.
Yes, the inner sanctum. We come up here at noon after the morning cases, generally 3 cases, and again at the end of the day for the afternoon 3 hours worth of argument.
And is it a spirited discussion?
It often is. We can spend a great deal of time hashing things out in addition to all of the written work that goes back and forth.
The chief assigns one of the justices, and sometimes himself, to write the court's opinion. Then the work moves to the individual chambers. Unless the arguments have changed things significantly, the memorandum prepared before argument is generally the starting point for a draft opinion. All 7 justices must sign off on every word of an opinion, or write separately, concurring or dissenting. To help with their research and writing, the justices each have a staff of permanent research attorneys. There are no quill pens at the Supreme Court. Much of what was once paperwork is now in electronic form. The back and forth may go on for weeks, but under the state constitution, the justices have only 90 days after hearing arguments to render a decision. All decisions are in writing and are published and immediately made available on the Internet. About 20% of the court's work, and a large amount of its paperwork, consists of cases in which the death penalty has been imposed. The Supreme Court must hear every death penalty case.
In every death case.
And if it affirms and an execution is scheduled, the court is involved until the very end.
There is an open line that is connecting our court as we gather around the Chief Justice's conference table to the death chamber in San Quentin in case there should be any last-minute stay request or petition filed with us. And when the execution procedures start, which generally is a minute or 2 after midnight, the associate warden or one of his designees typically will ask the clerk of the court who is with us whether there is any cause pending before the California Supreme Court why the execution should not go forward. So we end up being involved in a rather solemn duty there, and there have been occasions where there are last-minute filings with us and we are here half the night, or in one instance I can think of after 6 a.m. in the morning until all legal challenges are resolved and the matter is finally disposed of.
Matters of life and death, of liberty, questions of justice. This is the work that takes place inside the California Supreme Court.
Please join me in welcoming the 27th Chief Justice of California, Ronald George. Well, Chief, born in Los Angeles area, educated in law school at Stanford, a judge on the LA Municipal Court, the Los Angeles County Superior Court, the Second District Court of Appeal, Justice and Chief Justice of the Supreme Court. You are a son of California.
Feel that my roots really are in California, and I've had some involvement in national organizations, and I'm proud to say that California is always looked up to as a leader in its judicial system.
So let's start at the beginning. Out of law school, you went to work with the Attorney General's office, the California Department of Justice.
That's correct. And the Attorney General then was Stanley Mosk.
Who you would encounter at several points in your career.
Well, Stanley Mosk joked at some event which he was presiding that he started off as my boss when he was Attorney General and I was a young Deputy Attorney General just out of law school. Then he was appointed to the California Supreme Court, and at that point I was arguing cases before him as an advocate, And then thirdly, I was appointed to the Supreme Court, and we were associates on the same court. And then fourth, as he put it, I became his boss.
And as a deputy attorney general, you had a chance to practice not only in Los Angeles, but also in some of the outlying areas, including Santa Barbara County, right?
That's correct. My assignment was mainly appeals from the State Court of Appeal and then the State Supreme Court, and then ultimately 6 appearances before the U.S. Supreme Court. But I also did some work for the trials and investigations section, which caused me to come to Santa Barbara and other counties to investigate and try cases.
And they didn't always care what the boys from LA thought, I understand.
Most definitely not. If you went down to Imperial County in those days, you were looked on as if you had come from some far off country and were regarded with distrust or suspicion.
You write about a sign that was in some of the clerk's offices.
Yes, I think it said, maybe not quite this politely, "We don't give a darn how you do things in LA."
And that included one significant and somewhat notorious hearing here in Santa Barbara at our own mural room. Tell us about that.
Yes, well, what happened was there were the Isla Vista riots connected to the University of California, and it was an era of a lot of student riots, but this one became quite out of control, and the National Guard was called in to assist local law enforcement. And because of some disqualifications, I was assigned by the Attorney General to come up here and have state involvement in the investigations and various proceedings. And one of those ended up being a tragic occurrence. There was a student at UC Santa Barbara named Kevin Moran, and in the course of the student riots at the modular Bank of America that had been set up in Isla Vista, he was shot and died as a result of that incident. And I was sent up with an investigator to figure out the cause, how this had happened. And if you want me to briefly indicate what we found, I'll go
Yes,
ahead.
please. It's an interesting case. Some people here may actually remember it. Yeah. Yeah, there you go.
Well, it was rather tragic. There were students who were protesting against the bank, and some of them were right on the steps of this modular structure. And all of a sudden, a gunshot went off, and the student, Kevin Moran, was dead. And I was sent up to investigate how this happened with an investigator. And the initial gunshot was determined to have come from the fact that a law enforcement officer jumped out of his vehicle, and possibly due to a defective safety, the weapon discharged accidentally, but it was hard to figure out how he got killed because the weapon was pointed straight upwards. There was a fence in between the officer and the Bank of America steps. And I had the benefit of the Department of Justice Criminal Lab. So they're really the ones who solved this whodunit. They examined the bullet and they found that there were 2 items inside the meshed, folds of the bullet that went into Kevin Moran. One was a white mineral substance, and another was a fiber that did not match anything that was worn by Kevin Moran. And the lab figured out that during the course of this protest, when white limestone rocks from the rooftops were being hurled by the protesters at the bank, that when this weapon went off, it ricocheted off a white limestone rock that had been thrown in the air and then had a downward trajectory passing through the garment of the person standing next to Kevin Moran, where it picked up this fiber and then killed him. So that was quite a whodunit, but since local law enforcement was removed themselves from the case, they were disqualified with their own officers being involved. I was asked to come up by the Department of Justice and conduct the investigation and the coroner's inquest in your beautiful mural room.
It was a multi-day affair in the mural room, right?
Yes, it was. I think it was about 3 days, if I remember correctly.
And you were the person on your feet the whole time.
I was with tile floors. I still remember it. I was a young man, but I was the only lawyer putting on the whole proceedings. It was one side rather than a contested opportunity to sit down occasionally. So I had a real appreciation of all the beauty and majesty of the courtroom and a little bit of sympathetic ache to my back from standing on the tiles for 3 days.
And then you became sort of a specialist in the death penalty.
I did somehow, and I was assigned to, ultimately, after arguing several death penalty cases as a deputy attorney general. And those cases, by the way, under our state constitution, go directly to the California Supreme Court without the case going through the Intermediate Court of Appeal, as do all other cases. Well, I was involved ultimately when the case went up there. I'd had several cases involving the death penalty, including the Sirhan prosecution for the assassination of Robert Kennedy. But then finally, when the death penalty itself was under attack, I was assigned to argue in the state's case in favor of the death penalty, and then did so again before the United States Supreme Court.
And I wonder if that's not work that later you might have had second thoughts about after you were on the Supreme Court and you had to review all those death cases.
Yes, because under the Constitution, all criminal cases go through the State Court of Appeal except death penalty cases, and those go up straight away. So with enormous transcripts, the cases often take several months, and it's a major part of the court's caseload, even though, in fact, there has not been a death penalty carried out in for numerous years.
You said 20 to 25% of the court's time during your service was on
Yes.
death cases.
Yes.
And you eventually decided that it was almost not worth it. Is that right?
Well, it was my job to represent the state's interest and under the Constitution had the interest in, having a death penalty. But as a practical matter, there was an enormous amount of resources, human and financial, put into those death penalty cases. And I guess it became my view that the people had the right to have a death penalty, but that it was perhaps not worth all the time and effort and expense if the courts were not allowing the death penalty to proceed. And that was a judgment call that had to be made by persons other than myself, of course.
You had a very astute observation, I thought, that was picked up by the New York Times as the quote of the day, that people on death row are more likely to die of old age
That's correct.
than of execution.
It's correct that I said it, and I still believe it is correct as a matter of fact.
Yeah. All right. We haven't even gotten you on the bench yet. At the ripe old age of 32, you were appointed to the Los Angeles Municipal Court and then eventually elevated to the Superior Court. What made you think you would be a good judge?
I think I had enough of a sense of even-handedness, because to be a good lawyer, especially a public lawyer, you have to see both sides, both to further your own side and as a matter of fairness as a public lawyer. And I thought I had that ability, that really my training as a deputy attorney general, both in investigations and in appellate arguments before the State Court of Appeal, the State Supreme Court, and then 5 times before the U.S. Supreme Court, gave me that perspective that I could perform that function.
And you ended up being the judge in one of the more notorious cases in Los Angeles during that time, the Hillside Strangler case.
Yes, that was, it'll be hard for you to believe this, but 2 years and 2 days with the jury, and they are truly the heroes. The last 30 days of which they were confined after court hours in a hotel. So they actually were cut off from the rest of the world for 30 days. And before that, certainly during their daytime pursuits, they were isolated Monday through Friday.
And was that partly what made you interested in going back to your roots as an appellate lawyer and seeking appointment to the Court of Appeal? That must have, in some ways, felt like a natural step up for you.
It did. I mean, my real training was in the appellate sphere, although we had a trials and investigations unit, and that's what caused me to come up to Santa Barbara on some cases. But the major one, was the Kevin Moran case, but there were other cases all around that I got to participate in.
And there was some talk of promoting you to the federal courts, but you decided to stay in the state system as well and on the Court of Appeal.
Well, it may sound a little bit presumptuous for me to say that I decided, but I will say this, that
But I think also correct, isn't it?
I thought it was a wise decision at the time, and I do even more so now. But I sought the advice of the then Chief Justice Malcolm Lucas, who had experience as both a federal judge and a state judge. And I said, this is an awkward situation. The federal government asked me to fly back to Washington for an interview to be appointed to the Ninth Circuit, and I'm under consideration by, the governor. And is there anything wrong? He says, no, nothing wrong with being out for consideration for appointment by either or both systems, but it would be wrong for you to accept one and then 2 or 3 months later say, no, I'm switching to the other. So I gave thought to that, and despite being asked to go to Washington for an interview, I told them that I was not interested. My real pursuit would be to stay in the state system.
And you were rewarded for that. In 1991, you were appointed to California Supreme Court as an associate justice. And then in 96, you became Chief Justice.
That's correct.
How did that all happen?
Well, it's hard to know really what goes on in the minds of the appointing powers, but it seemed that there was, in the appointing power, there was acceptance or satisfaction with what I had done in my career in the Attorney General and as an associate justice. And I had some administrative experience too. I had been on a rotating basis in charge of the Los Angeles office of the Attorney General. And I think Malcolm Lucas, who was the Chief Justice, gave me some duties to assist him on our legislative program going to Sacramento and generally in various administrative tasks. So it's sort of just happened. It wasn't anything that one could or should actively pursue.
Well, that's a very modest answer and true, but as an editor of the legal press at that time, it was pretty much suspected, shall we say, that he was being positioned to take the Chief Justice's job when Justice Lucas retired. And in fact, that is what happened. And it turned out to be very good timing in a sense, because you really became the person in charge of finishing the project, seeing that the project was finished that got the court back into its historic home.
Well, yes, and your audience may be interested to know that being Chief Justice is not exclusively or by any means the major part of running the court itself. The title is actually, under the Constitution, Chief Justice of California. And that means that there is responsibility not just for the court of 7 on which you sit and its operations, but also responsibility for the entire state system. And I soon realized that there were a lot of administrative challenges and opportunities for reform that I should pursue. And in fact, in my initial State of the Judiciary address to a joint session of the legislature, which came every year, I made a commitment that some thought I should have been committed for making, and that was that I would visit the courts in each one of our 58 counties. And that was a real
You sort of talked yourself into a real task there.
I did, and it was remarkable. I mean, just one tale, going to Sierra County, I was met by the local reporter who said that he was also the editor and the publisher and owner of the publication. And not only that, he was the delivery boy. And especially in the winter months, he would himself fly Cessna without anybody accompanying him and try to drop the local newspaper as close to the front porch as possible. And he claimed to be a distant relative of the Wright brothers, and his last name was Wright, so I didn't question that.
But it was that tour of the 58 counties that really informed a lot of your program as Chief Justice, right? What you saw in visiting those different courts.
Exactly, Tom. It really did, because I saw a lot of duplication between our structure of trial courts. We had 3 levels: Justice of the Peace Courts, Municipal, and Superior Court. All of those 3 were trial courts, depending upon the population of the area and other factors, historical and otherwise. And I learned a great deal about the deficiencies. There were courtrooms that did not have a jury room for the jurors, a jury assembly room. And I saw in one place the jurors seated on the steps to an upper floor, and they had to move over in their seat as a chain gang of prisoners were brought down from the custody area past them into a courtroom in which they would then sit and pass judgment. So there were a lot of things that I observed, and given my responsibilities being statewide, it convinced me that there were 3 major reforms that I wanted to tackle, and we can go into those if you'd like.
Yeah, so I mean, every justice leaves his mark on the law and the opinions that are in the law books, but your fingerprints are on much more than that, in that the trial courts were all unified while you were chief. The state took over funding for the courthouses. Not a task that's finished, some of our court administrators would tell us, and took ownership of all of the different courthouses as well. 3 really fundamental changes in the California judicial system.
Yes, it really made it into a state system and not a hodgepodge of uncoordinated efforts. So the justice of the peace courts, the municipal courts, and the superior courts were unified under the Trial Court Unification Act.
Not always to the great delight of the Superior Court judges, right? Who took their title seriously.
Definitely. And I think perhaps Los Angeles especially thought it was a kingdom unto its own and did not appreciate direction. But as you say, the responsibility as well as the title is to be Chief Justice of the state and to consider the the good of the public and of the judicial system, and not just cater to what individual judges might prefer as a matter of convenience or habit. So we ended up having those courts unified into one level of trial court. And then there were the courthouses, and they were passed from county ownership and maintenance, using the term loosely sometimes, of maintenance. And then the funding of the system, all of it, the ownership, maintenance of the buildings, all of that was part of a plan to make it a unified court system.
And that led to a great number of trips for you from San Francisco to Sacramento to meet with the legislature.
It did. And also, interestingly enough, my wife, Barbara, who's here today, was chair of another California agency, the California Arts Council, and she was making her tours around the different counties to try to firm up support for the arts and for music education. And in fact, on one occasion, it was rather amusing. She and her colleagues came out of one senator's office as I was coming in. And I think it was John Burton. He said, "I'm really getting a double whammy here from the George family."
Many, many cases came your way during your service on the bench, but maybe the one you will be most remembered for at the Supreme Court is the same-sex marriage case.
Yes.
Tell us how that happened, because it really was a somewhat revolutionary opinion that not many people had even thought about 5 or 10 years before. And all of a sudden, you led the court, and you led the court in making that change. How did that happen?
Well, the issue was raised when the mayor of San Francisco chose to issue through his clerk marriage licenses to same-sex marriage, and that was Gavin Newsom. And the court intervened when there was a writ petition filed with us, saying that the fact that the mayor did not agree with the current law did not provide him with a basis for disregarding it, and therefore he could not act legally in doing so, that if he wished to challenge it, the way was, as it would be for any citizen, to file a lawsuit. So
you started by shutting down what Gavin Newsom had done in San Francisco.
said, if you or anyone wants to do that, you go to court. But because we couldn't have a situation where everybody, even every mayor or local official, would decide which laws he or she liked and didn't. You could have somebody in one part of the state say, I hate these laws that are for gun control, and I'm not going to apply these laws because I believe there shouldn't be any restrictions on gun control. And you could have people in other parts of the state decide which laws they would and would not enforce. So the way to do it is not for any one of those hundreds or thousands of local officials to decide which laws they thought themselves were good or constitutional and which weren't, but instead to go file a lawsuit. So although we slapped down the first effort, then the mayor went ahead, filed a lawsuit, which ultimately made its way up to our court. And I believe it was originally that the trial court went the mayor's way. The court of appeal, I believe, 2-1 went the other way, and then we took it up. And I assigned the case to myself.
As you often did for major cases that came
Yes.
before the court.
But what I did here was a bit unusual. I wrote up a proposed decision before oral argument, going one way and one going the other way. And what was also
Wrote the decision both ways.
both ways. And then which was also very unusual, I went around and scheduled an appointment with each of the 6 associate justices in their chambers, where I just went in myself and I said, I've written it up both ways here. Read it and let me know what you think of it. Well, I heard back from them 3-3. So I was in the decider's chair on that one. What was interesting, and I won't go on too much about this, but in terms of what led me to pick one version over the other was, even though there may be seemingly brand new issues, the courts try to look to precedents to guide them and apply those precedents, to a new situation. And there was a case called Perez v. Sharp that the court had issued sometime in the late 1940s, I believe, that this California Supreme Court had issued. And that case involved a challenge to a statute that California had, a statute that prohibited interracial marriage. And if you read through passages of Perez v. Sharp, Perez being one of the applicants, Sharp being the registrar, the language fit right in. It talked about the sanctity of marriage, the importance to the lives of the participants and to the community sense, and the children were offspring and so forth. And there were, whole passages that fit right into the context, even though it was a very different case of marriage from the same sex. It was fundamentally a question of interpreting that language on the racial discrimination statute involving marriage.
And we might note that it took another 20 years before the United States Supreme Court came to the same decision about interracial marriage.
Yes.
And so you really,
Often a leader and a head of the U.S. Supreme Court.
yeah. So you really saw this not as a same-sex marriage case or not as an interracial marriage case, but as an equal protection of the law case.
Yes, exactly. One can challenge a distinction made by the law if there isn't any basis for making a distinction. And that was certainly the case when one analyzed the fundamental nature of the institution, the right to have that relationship recognized with all the tangible and intangible benefits and attributes.
And this time it wouldn't be 20 years before the United States Supreme Court followed. It took only about 5 or 6
Yes.
before they made the same ruling. Yeah. That stay with you as a positive development in the law during your time on the bench?
Well, it did certainly, because what was perhaps a bit of a startling decision for some soon became the norm and as recognized by the United States Supreme Court. So we weren't out on a ledge with Massachusetts by ourselves, but it was something that given the nature of the institution, it seemed that the court really had no other way to go if it examined and followed its precedents.
And to that point, though, about the California Supreme Court being what we sometimes call the most followed Supreme Court in the country, that really is true. And there's fairly compelling empirical evidence to support that the California Supreme Court often gets there before other courts in other states.
Yes, it's been true in other areas such as consumer rights and other matters as well.
He doesn't look like a radical, does he?